Nigel Tate Carter-Ruck. One of Lord Justice Jackson's proposals is that successful defendants to libel actions will not be able to recover their costs in future, except in limited circumstances. Does the panel have a view on that, and what will that do for freedom of speech? Is there any point in having a widened public interest defence if you can't afford to use it, because you won't get your costs back if you're successful?
It's another limb of Lord Jackson's proposals, which is goes even further and says there should be no cost recovery at all. At all. Yeah, forget the success fee. So it's even more draconian. That part of the proposal.
And what's the answer to the questioner that this is another way of freezing, another way of sort of making access to justice much more difficult?
I'm afraid I don't agree with Lord Justice Jackson's proposals, and I think there's a better way of doing it.
Gavin Souter, I, for my sins, am a lecturer in media law at Queen Mary University of London. Two very quick points I wanted to raise. One is I have heard right throughout the entire debate on libel reform over the last couple of years, endless mention of we need to change the position for intermediaries. Westminster cannot do that due to obligations under the Electronic Commerce Directive at the European level, and that's something I hear very little, very rarely addressed in this debate. The other issue is referring to the American legislation that was mentioned, the so-called Speech Act, which was one of these absurd things, some endless securing protection for our enduring and established constitutional heritage, I believe, so-called for the acronym. Well, I've long had cats, and what cats do round a garden is precisely what that act was and nothing more, because clearly under the US Constitution, under the First Amendment, if something breaches that, the courts will throw it out and refuse to enforce it. That should concern us absolutely nil in England and Wales, simply because we should be concerned with reforming the law to the correct position as it should be here. If somebody can't enforce that in America, tough, nothing to do with us. I would be curious to see whether the panel feel that we should bestow any more significance than that on the Speech Act.
I would say there are four elements to the public interest that would really inform discussion on this. I think the first is, that people have mentioned, is that there is little quick, easily disposed of access to resolving disputes, and we've only heard a few mentions of some of the ways that we might look at that. The media themselves need to look sensibly at how they, with offer of amends we have, but also I think PCC's been raised, and ADR, I know that the Media Standards Trust is looking at alternative dispute resolution in collaboration with others at Index and Pen. And I think there are a lot of things that need to be given proper consideration because, as I think Martin Moore's often made the point, that the courts are here encroaching in an area where other ways of resolving disputes have fallen short. It doesn't mean it's the best way to resolve it, and no libel law is going to be satisfactory. People don't want to spend 3 months and £10,000 realistically. So something county courts perhaps we need to look at as well. In a lot of these cases, we need to look a bit more at the context and to trust people to make some value judgments about what they read. And finally, I think we have to look a bit more at the way that public interest has been recognised in case law so far.
Eddie Craven, Matrix Chambers. The last 10 years have seen enormous developments regarding protection of privacy interests in the UK. I was just wondering to what extent the panel think that when we're considering appropriate libel law reforms, we should also have regard to the state of the law on privacy. To take one example, how do the panel feel about the relationship between the law of privacy and libel in situations where a claimant may invoke the law of privacy in order to circumvent, for example, some of the restrictions on, for example, obtaining an injunction that would obtain if they went in an ordinary defamation claim?
Just on the issue of libel tourism, we have Peter Wilms here, who did an interview to an American online journal at an American conference in America to an American journalist, ends up being sued in London. Henrik Thompson Dane ends up being sued by the American GE company in London. You have Francisco Lacerda has his article sued for libel by an Israeli technology company, even though he's Swedish. I was in Australia just before Christmas, and I'd given an interview to an Australian health correspondent who couldn't print his interview in detail because his lawyer said he was scared of what might happen in an English court 12,000 miles away. I spoke about the most touching case, I think, was of a woman, Loretta Maron, who's a citizen journalist who takes on quacks and quack remedies in Australia. And she relies very heavily on academics and experts backing up her complaints and her lobbying of state legislatures and so on. And she's now in a position where those experts and academics will not allow themselves to be quoted in her report for fear of being sued for libel back here in London, 12,000 miles away. So the issue of libel tourism is incredibly important. And I think, as Nick Clegg said last Friday, instead of being a cause for international embarrassment, we really need to have a libel law that's a blueprint for international standards.
Can I hear a round of applause for him? The question of reversing the burden of proof, none of you on the floor picked that up. Worrying, we lawyers never like to see such fundamental shifts, but isn't there, is this the time to be having more debate about that? And the strengthening of a public interest defence and the questions that raises to whether it would be any very different from the whole Reynolds defence or not, and how that could be done. The problems around money and costs are absolutely the heart of all of this. How can ordinary people feel that they can have access to the courts so that their reputations matter as much as those of the rich? And if you're going to have any system of justice that's worth its name, then we have to be able to address that whole problem. And different ideas have come up tonight. Many of them we'll take away with us, but I really do hope that we will see some serious change in this next period to come, and that there will be the urgency around Parliament to get something done. So I want to thank all of you. Great questions, great contributions from the floor. Let's keep this debate going. It's really important. Over to you.
Thank you very much, Helena. And I, on behalf of Gray's Inn, INFORRM and the Media Standards Trust, I'd first of all like to add my thanks to those of Helena, to the panel members for their contributions.